Hi, I'm Art Zimmet of the child injury law firm Zimmet and Quarles. Can a child be negligent? That's the question I'll answer today. I recently heard this question from a man whose daughter was injured at gymnastics practice. She was being stretched by a friend who was going too far. She told her friend to stop, that it hurt. However, her friend did not stop and she suffered severe injuries. Her injuries were a broken pubic bone and torn muscles. This question is, can the child be held liable, or her parents, or the gymnastics instructor, maybe the facility? Can anyone be held liable for this injury? Under Florida law, there is no specific age at which children become old enough to be considered negligent. The rule is that their behavior is judged by the child and how old they are and how smart they are and what experience they have in the activities that they are engaged in at the time an injury occurs. That is, unless the child is doing an activity that usually only adults engage in, such as driving a car, driving a boat, or flying an airplane. If the child is engaged in these types of activities, the child is held to the standard of care that a normal adult would be. So again, if a child is engaged in an activity that children normally engage in, the child is only expected to behave as a child of that age, intelligence, and experience is expected to behave. So, this is a question only for the jury. Lawyers and judges cannot answer the question of whether or not the child was behaving according to the standard of care that we expect children of that age and intelligence and experience to behave in. In the specific case of the girl injured at gymnastics practice, the question is, did the facility or the instructor have a duty to protect the child, and if so, did they breach that duty? If a jury considered it reasonably foreseeable that injury would occur in the event that the instructor left the children unsupervised, then that instructor had a duty of care to protect the children by supervising them. If the instructor simply told the children to stretch and then left to make a phone call or smoke a cigarette, then it's likely that a jury would find that instructor negligent. However, if the instructor said, "This is the proper way to stretch," and then supervised them while they were stretching, it's unlikely that the instructor or the facility would be held negligent. One important thing for parents to remember in situations like this is that liability waivers are binding. If this man signed a waiver saying that the facility and the instructor could not be sued in the event his daughter was injured, that document is binding. Remember, if you or a loved one have been injured, you might not need a lawyer. But before you sign any forms, talk to an insurance adjuster, or hire a lawyer, do yourself a favor. Get the free books and valuable information available at our website, zqlawyers.com. They're free, and I'm confident you won't be disappointed.